Writ Petition Criminal Number 406 bar 2023, Supreme Court of India, Court Number 11, Section PIL W. Tushar Gandhi, Petitioner versus State of Uttar Pradesh and others. Date 25 September 2023. Quorum Honorable Mr. Justice Abhay S. Oka, Honorable Mr. Justice Pankaj Mithal. Upon hearing the counsel, the court made the following order. We have perused the status report submitted by the state of Uttar Pradesh. After a long delay, the first information report was registered on 6th September 2023, alleging the commission of offences under Section 75 of the Juvenile Justice Care and Protection of Children Act 2015, for short JJ Act. Apart from Section 75, which is a cognizable offence, Sections 323 and 504 of the Indian Penal Code 1860 have been invoked. The submission of the learned counsel appearing for the petitioner is that, in fact, the offence is under the second proviso to Section 75 of the Juvenile Justice Care and Protection of Children Act. Additionally, he submits that, in view of the complaint made by victim child's father, even Section 153 capital A of the Indian Penal Code will have to be applied. The police cannot ignore the communal angle which is reflected in the complaint. Considering the manner in which the police have delayed action, and especially the fact that though a case of cognizable offence was made out, only a non-cognizable case was reported, we direct that the investigation shall be conducted under the supervision of a senior IPS officer nominated by the state government. The state government shall do the needful within a period of 1 week from today. The IPS officer so nominated will go into the question of whether the second proviso to Section 75 of the Juvenile Justice Care and Protection of Children Act is attracted and whether Section 153 capital A of the IPC needs to be applied. The IPS officer so nominated shall be responsible for submitting the compliance report to this court on this aspect and for reporting the progress made in the investigation. Learned Additional Solicitor General ASG raised an objection to the locus of the petitioner. He states that the petitioner cannot make capital of the fact that he is the great grandson of Mahatma Gandhi. In fact, in a case like this, the state should not be really concerned with the locus of the petitioner, inasmuch as this is a case not only of the failure to effectively set the criminal law in motion, but also a case where there may be a violation of the fundamental right of the victim under Article 21 capital A of the Constitution of India, as well as violation of the rights under the provisions of the Right of Children to Free and Compulsory Education Act 2009, for short RTE Act. Moreover, we find that there may be a breach of the provisions of the Uttar Pradesh Right of Children to Free and Compulsory Education Rules 2011, for short the said rules. Therefore, even assuming that there is any merit in the objection raised by the state government, this court can always treat the petition as a suo motu proceeding. Therefore, this objection need not detain us. As the investigation is pending, we are not going into the merits of the allegations. However, we must note that the allegation is that a teacher, while finding fault with the victim for his poor performance, directed the other students to assault or physically punish the victim. The allegation is that this was done by the teacher because the victim belongs to a particular minority community. Clause 3A of the Statement of Objects and Reasons of the Right to Education Act clearly lays down that free and compulsory education should be of satisfactory and equitable quality in a formal school which satisfies certain essential norms and standards. Under Section 8G of the RTE Act, it is the obligation of the appropriate government to ensure good quality elementary education. The same is the obligation of the local authorities under Section 9H of the RTE Act. We may also note one more aspect of the matter. Under subsection 1 of Section 17 of RTE Act, there is a complete prohibition on subjecting a child to physical punishment or mental harassment. If the allegations made by the parents of the victim are correct, this may be the worst kind of physical punishment imparted by a teacher, inasmuch the teacher directed other students to give physical punishment to the victim. When the object of the RTE Act is to provide quality education, unless there is an effort made to inculcate the importance of constitutional values in the students, especially the core values of equality, secularism, and fraternity, there cannot be any quality education. There cannot be quality education if, in a school, a student is sought to be penalized only on the ground that he belongs to a particular community. Thus, there is a prima facie failure on the part of the state to comply with the mandatory obligations under the RTE Act and the rules framed thereunder. We may also note that under Sub-Rule 3 of Rule 5 of the said rules framed by the state government, there is a mandate that the local authority shall be responsible for ensuring that no child is subjected to caste, class, religious, or gender abuse or discrimination in the school. The state government is under an obligation to enforce and implement the provisions of the RTE Act and the said rules. Victim must have undergone trauma. We direct the state government to ensure that proper counseling is extended to the victim of the offense through an expert child counselor. Even the other students who were involved in the incident, in the sense that they allegedly followed the mandate issued by the teacher and assaulted the victim, need counseling by an expert child counselor. The state government will take immediate steps to do the needful by providing services of an expert child counselor. The state will have to answer one more important question. The question is, what educational facilities the state will extend to the victim of the offense for discharging its obligations under the RTE Act and Article 21 Capital A of the Constitution, which means that the state must make proper arrangements for providing quality education to the victim in terms of the provisions of the RTE Act. The state cannot expect the child to continue in the same school. In this stage, the learned Additional Solicitor General assures that the state does not want to protect anybody and will ensure that the law is implemented. The senior police officer appointed in terms of this order shall submit a compliance report as well as a report on steps taken in the investigation. He shall provide to this court the copies of the transcripts of the conversation in the video clip of the alleged incident. The state shall submit a compliance report on providing better education facilities to the victim of the offense and complying with the direction to undertake counseling of the victim and other students through an expert child psychologist. After looking at the report, we will consider whether further directions are required to be issued to ensure that there is no violation of subsection 1 of section 17 of the RTE Act. The RTE Act is aimed at providing compulsory elementary education to strengthen the social fabric of our democracy. The emphasis is on giving equal opportunities to all to get access to the facilities of education. Moreover, there are detailed guidelines for eliminating corporal punishment in schools laid down by the National Commission for Protection of Child Rights, established under the provisions of the Commissions for Protection of Child Rights Act 2005. We direct the state government to place on record the said guidelines. We expect the state government, senior police officer to submit the compliance reports on both aspects within a period of 4 weeks from today. We direct that the state of Uttar Pradesh be also implemented through the Secretary of the Education Department so that the aspects of compliance with the requirements of the Right to Education Act and the rules framed thereunder effective directions can be issued. The amended memo be filed within 1 week. The AOR, advocate on record representing the state, will accept the notice. The response of the Education Department shall also be filed within 4 weeks. List on 30th October 2023. 9 February 2024. Supreme Court of India, Writ Petition Criminal Number 406/2023, Tushar Gandhi versus the State of Uttar Pradesh and others. Upon hearing the counsel, the court made the following order. We have perused the report submitted by Tata Institute of Social Sciences, for short TISS. In the report, very detailed suggestions have been given by TISS about counseling of the other children who were participants and witnesses in the corporal punishment incident. We find from the affidavits filed on record that the state has not undertaken counseling of the other children who were participants and witnesses in terms of the suggestions of TISS. There was an element of urgency in counseling. We direct the state government to immediately implement the suggestions in TISS report about the counseling of other children who were participants and witnesses in the corporal punishment incident. Complaints affidavit shall be filed on or before 28 February 2024. There are other directions issued in the order dated 25 September 2023 regarding implementation of the provisions of the Right of Children to Free and Compulsory Education Act 2009 and UP Right of Children to Free and Compulsory Education Rules 2011. We grant time of 1 month to the state to report compliance in terms of the said order for dealing with the issue of counseling. List on 1st March 2024.